Hello and welcome to the Kenneth Verkaman Law Office Legal Podcast, the NJ Laws Tube, looking at recent cases by the Supreme Court. And we look at the United States Supreme Court's case of Florida versus Powell. And in that case, there was a challenge by a defendant saying that he was not read the same exact Miranda warnings as that in the original case of Miranda versus Arizona. But in Florida versus Powell, the Supreme Court said there's not specific exact words that are required for a valid Miranda warning. In this state prosecution for possession of a weapon by a convicted felon, a reversal of the conviction on Miranda court grounds was itself reversed and the conviction was reestablished. The Supreme Court held the police satisfied the Miranda warnings requirements by informing defendant that he had, quote, the right to talk to a lawyer before answering any of their questions, end quote, and that he had, quote, the right to use any of his rights at any time he wanted during the interview. Advice that a suspect has, quote, the right to talk to a lawyer before answering any of the law enforcement police officer's questions, and that he can revoke this right at any time during the interview satisfies Miranda. Now, some states have more stringent requirements, but at least in Florida, there's not a specific requirement to read from Miranda word for word. Florida versus Powell, the citation is 175 Lawyers Edition, 1009, decided December 7, 2009. For additional information on recent cases by our courts in criminal traffic matters, visit website njlaws.com. That's njlaws.com. And also website benotguilty.com. That's benotguilty.com. For other legal information, contact the Law Office of Kenneth Verkaman, 732-572-0500. They're at 2053 Woodbridge Avenue, Edison, New Jersey, 08817. Thank you, and we'll be back next week.